They simply couldn't believe that these primitives, as they called us, had a religion, and that the religion was based on attachment to places imbued with ancestral beings.
Welcome to Sacred Land Speaks, where we dive into the audio archives of the Sacred Land Film Project and revisit the interview clips we left on the cutting room floor over 40 years of filmmaking. I'm your host, Toby McLeod. Today we bring you part 2 of my 2010 interview with Professor Marcia Langton, an anthropologist and geographer of Yiman and Bidjara heritage in what's now known as Australia. In 2010, while working on our 4-part documentary series, Standing on Sacred Ground, we were looking for inspirational stories where Indigenous people had successfully protected sacred sites. While acknowledging the long, brutal history of settler colonialism in Australia, Aboriginal people there have celebrated some significant victories. We filmed with the Gurindji people in the Northern Territory, who were fighting against a plan to move the MacArthur River to make way for an open-pit zinc mine. The community was outraged about this threat to the river because the traditional owners said the powerful ancestral being known as the Rainbow Serpent lives there. They were inspired by the success of the Yungara people, who had blocked a mining company from drilling on sacred land at Nunkumba in 1978. I turned to the Chair of Indigenous Studies at the University of Melbourne, Professor Marcia Langton, to get the historical context of the movement to assert land rights and protect sacred sites.
The Aboriginal Land Rights movement is a complicated story. It starts essentially after the Second World War. So if I could start there, it gives you a flavour of how complicated it is. Until the Second World War, Aboriginal people were wards of the state, and their labour was not free. There was no freedom of movement. And Aboriginal people were sent on consignment to work as unfree labour in various posts, such as cattle stations. And that story is a terrible one. Along comes the Second World War and the movement of troops to posts around Australia, especially in the north. Now, many people think that because the law said that Aboriginal people were not permitted to be recruited to the war efforts, that there were no Aboriginal people serving. But that's not true. Aboriginal people have served in every war since the Boer War. Now, many Aboriginal people signed up to serve as non-combatants during the Second World War. And so they ran troop camps, they were cooks, butchers, labourers in the army camps across North Australia. And many signed up and served as combatants as well. So once they signed up with any of the Defence Forces, they were paid the same as anybody else, and this had never ever happened before. When Aboriginal people were demobbed at the end of the Second World War, they went back to their positions where their labour was unpaid, and the stark difference was brought home to them. As a result, from then on, starting in the Pilbara, Aboriginal groups organised strikes, and there were rolling strikes across North Australia from 1946 through to the 1970s. The most famous one of these strikes was the Gurindji strike. Basically, the Gurindji people were unfree labour on the Victoria River Downs and neighbouring properties owned by Lord Vestey, an aristocrat in England who was an absentee landlord. The practices on these cattle stations were very cruel, and Aboriginal life on these cattle stations was extremely harsh. They went on strike for equal wages and basically never went back to work. Their equal wages case, much like the Pilbara strike starting 20 years before, turned into a land rights movement. So they went from saying we want equal wages for our labour to, hang on a minute, this is our land. What are we doing? Why would we want to go back to work for these people? This is our land. And a huge number of Australians supported them. People came from the cities to the Gurindji lands and stayed with them and helped them to organise their campaign. And there were campaign committees in the cities. That's regarded as the beginnings of the land rights campaign. But what was happening at the same time was that case in the Northern Territory where the Yolngu around the mission of Yirrkala which was then a Methodist mission, took the mining company to the Northern Territory Supreme Court, arguing the first native title case, although it was not called native title at that time. So these events coincide. Now, Aboriginal people were not inherently opposed to mining. What they were opposed to was mining on sacred sites and the fact that nobody recognised that it was their land. Nobody asked their permission. Nobody consulted them. Simply declared a lease over their traditional country, and they found out about it afterwards. And of course, sacred sites were bulldozed. Now, whether the white people knew that this is what they were doing, who can tell? They might very well have deliberately bulldozed sacred sites, who knows? But this was the painful instigator of the conflict. In the Pilbara strikes, the way that the workers out on strike supported themselves was by panning for tin and other minerals and taking all of their panned minerals in old jam tins down to the assay office in Perth. And they saved up, in the first instance, £25,000 and bought a cattle station. And there were Aboriginal miners in many parts of the country. There were Aboriginal tin miners in Cape York. There were Aboriginal gold miners. So it's not mining itself, but it's the fact of the mining companies, with the support of the state governments, and in the case of the Northern Territory, the Commonwealth Government, taking Aboriginal land, even though, the law said it was not Aboriginal land, but Aboriginal people refused to believe that. Their consent was not asked, and the bulldozing of sacred sites, which so upset them. So from that time onwards, there was conflict over mining. By the time of the Mabo case in the High Court, which resulted in the overturning of the British doctrine of terra nullius, this is a land with no people argument, some of the mining companies were starting to rethink their attitude. Until then, and of course there'd been a mining boom in Australia, starting in the 1960s, a big mining boom, and great wealth was made, and this was the beginning of the large-scale industrial mining in Australia, with the longest conveyor belt in the world being built in the Pilbara, for instance. Huge pit mines opened up. Mining companies began to think about their approach. Now, what caused this rethink? The ongoing conflict with Aboriginal people was causing them reputational harm, and some companies actually cared about that. The events in Bougainville involving the company CRA, which later became Rio Tinto, resulted in a civil war and the closure of the mine. So the economic loss to the companies caused by social conflict caused a rethink. And so eventually, in the late 90s, some companies began to talk to Aboriginal people about obtaining what they call a social licence to operate. That is, security of tenure based on the goodwill of local people. It was when these discussions started in the late 90s that eventually good practices began to develop, so that companies that behave responsibly and aim for good practice, aim for obtaining the social licence to operate by consulting carefully with local people, began to protect sacred sites rather than destroy them. There were negotiations involving old mining operations that continued and required expansion. So these expansion projects became the subject of negotiations, which resulted in native title agreements. Now, what does that mean? It means that the native title will not be opposed at the end of the mining operation by the company, but that benefits will be obtained by the local people from the mining company as a recognition for the loss of the use of their native title, the enjoyment of their native title, and the loss to future generations of those native title rights. So gradually we find good practice, especially in the large operations. That's not to say that all companies observe good practice, but the standards are much improved from the willful destruction of sacred sites in Western Australia in the Nunkambah case in the 1970s, resulting in major social conflict. What was it that caused some mining executives to rethink this traditional approach of going into battle with Aboriginal people. It was the native title case, the Mabo case in the High Court, and the 2 years of negotiations following that case, when Aboriginal people negotiated with the Australian government the terms of the legislation to recognise native title. One of the key provisions, the Native Title Act, was the right to negotiate provision. This provision gives native title holders and claimants, for the first time in Australian history, a real say, not a veto, but a say in how development proceeds. Not in all cases, but in most cases. Now, many Australians believe that Aboriginal people have a right of veto. So, for instance, you'll find environmental groups saying that Aboriginal people have allowed development on their land. Well, this is not legally possible. Nowhere in this country do Aboriginal people have any kind of veto over development. In fact, the reverse is the case. The situation that Aboriginal people find themselves in every state and territory is that once a development is proposed on their land, or land that they might have under native title claim, they cannot say no to it. There is no legal provision in any law for them to say no, but they can negotiate conditions. Conditions of access, protection of sites, and so on. This is misrepresented in the public by media, by environmentalists, by pastoralists, by farming groups, as Aboriginal people having a veto. It's not the case. But intelligent mining executives have worked with these negotiating events to ensure that the outcome is a win-win situation. And so, even if the intent of the law is to deny Aboriginal people a veto, through the negotiations, mining executives will say to Aboriginal people, well, because we want your consent to a 25-year operation or a 50-year operation or a 100-year operation, and we want you to benefit from this operation, then let's see what conditions we can negotiate so that your community will be better off at the end of this project than it is now, so that the company leaves with the reputational issues improved and the life of the project goes well for all concerned. Now, that's the best case scenario. It doesn't happen in all cases, not by a long shot, but when it does happen, that's when things are what we call good practice.
I asked Professor Langton if she could tell me the full story of the battle to protect sacred sites at Nunkamba.
In the 1970s in Western Australia, there was a mining boom, and exploration companies were desperate to find deposits. It was like a gold rush. There were small exploration companies fanning out across that large state looking for deposits because they could sell the rights to deposits to major companies and make an enormous profit. And during this mining boom, a development approach became a high priority in government policy in the Western Australian government. The government at that time in Western Australia was led by Sir Charles Court. And part of this development approach, instigated by the Chamber of Mines in Western Australia and various mining lobby groups like the Australian Mining Industry Council, as it called itself then, depicted the opposition of Aboriginal groups to the many mining operations and exploration operations occurring across the state as backward opposition to development and enrichment of the nation. So there were television advertisements and speeches by politicians that depicted Aboriginal people as the enemy of the state. And it was extremely racist propaganda. So in the midst of this frenzy of anti-Aboriginalism and pro-mining operations, the traditional owners of the Nunkamba cattle station opposed an exploration company which intended to drill on a sacred site. And they went to their friends across the Kimberley region, and there was a voluntary group established at that time. It was the beginnings of the Kimberley Land Council, led by the late Mr. Bindery, a Walmajari man who'd come as a young man out of the Western Desert. And together these men organised a campaign against the AMAX company, the exploration company. The campaign resulted in a very interesting film called On Sacred Ground. There were people rallied across the state, and so when Charles Court, the Premier of the state, sent the drill rig from Perth to drive northwards, a very long way, a couple of thousand kilometres, along the highway to Nunkanbar, people lined the highway to try to stop it, all the way up the Western Australian coast. And then at Nunkanbar itself, tribal men and women from all over the Kimberley gathered and sat down on the roadway to stop the drilling rig from going through. The police moved in. There were missionaries and church leaders there sitting down with the Aboriginal people as well, I might say. So the police moved in and dragged everybody away. The drilling rig went into the station. They drilled the site and found nothing. And it caused a great deal of heartbreak and sadness amongst the Aboriginal people. But essentially it was a political exercise. It was not about finding oil. It was a political exercise to humiliate Aboriginal people and to show that state power could be wielded to override Aboriginal interests. Well, of course, that might have been the intention of Sir Charles Court and his cabinet, but it inflamed Aboriginal people and it led to 2 decades of conflict with Aboriginal people in this country. Many mining companies bore the brunt of Aboriginal campaigns because they were unwilling to give in to any Aboriginal demands to protect sacred sites. It was an ideological point being made that there was no room in this country for Aboriginal religion, and if these primitives wanted to talk about sacred sites, one can only say that they are lying. These are the kinds of speeches that they gave. Mining companies talked about Aborigines inventing sites. They talked about mobile Aboriginal sites. They purported that Aboriginal people were moving sacred sites all over the country, imagining sacred sites, inventing sacred sites to try to use these as a case to extract payments in money from mining companies. None of this was the case. They simply couldn't believe that these primitives, as they called us, had a religion, and that the religion was based on attachment to places imbued with ancestral beings. It was a case of extreme religious intolerance. It was a case of state-wielded power and force to suppress a religion.
The image of Aboriginal people and their allies lining the long highway to block that mining rig from its destination is a powerful one. But most of the land rights struggle actually took place in courtrooms, and Marcia Langton is a renowned legal scholar.
There were many losses along the way, and Aboriginal people spent a great deal of money in courts. The first case was back in 1960. It was the Pine Kinna case. Then there was the Kawata case. Then there was the Mirlapum case. And there were many more cases after that. Do you know that Aboriginal people have been to the High Court of Australia probably about 40 times, perhaps even more, on issues of law? So now, as a result of so much Aboriginal resistance through the courts, through public campaigning, we have a relatively high standard of laws that protect Aboriginal rights compared to some parts of the world. But at the same time, the Aboriginal side can never stop being vigilant, because always a state government or a lobby group or a company will try to find a loophole or to break the law. Environmental groups in particular have no respect for Aboriginal property rights, for Aboriginal native title, for native title rights such as the right to be consulted. And so the need to be vigilant grows greater with globalisation, with yet another mining boom. Then this mining boom is bigger than any of the previous mining booms.
Marcia Langton says one of the most important outcomes of what's been recognized through all these court cases is the unique legal concept of communal land ownership, referred to as native title.
Aboriginal groups own their traditional estates of land and water and sea jointly. That is, the members of the group, of the clan, of the language-speaking group, or whatever the local social structure is, own the land and sea together in common. And while there might be some variation in the rights and authority of an older person against a younger person, nevertheless each person born into that group jointly owns the property of that group with all of the other members. And that's what's meant in Australian common law by the phrase communal title. So native title, recognised under the Native Title Act, and all of the traditional Aboriginal land rights titles under various pieces of legislation are forms of communal title. And if Aboriginal people during the land rights struggle wanted anything, what they wanted was communal title, because land and water estates under Aboriginal law cannot be owned by an individual unless that individual is the last person left standing of that group, right? In all other circumstances, the group owns the property communally because the property, the land and the waters, are inherited from ancestral beings who helped to make the world. So, one of my dear friends wrote about this way of owning land as a sacred legacy. So Aboriginal land and water is a sacred legacy inherited from the ancestors in the sacred past. Australian titles, on the other hand, are based on the individual right to own property and also the right to alienate property, that is, to buy and sell property. And it's been this way in market societies since at least the 17th century. Aboriginal society is not a market society. It's a kinship-based society. And hence you have these very fundamental differences in the way that people own property. Now, in the Aboriginal world, my personal property, such as my clothes or my digging stick, they're my personal property. I own them, and only I have the right to give them to somebody else. But land is inherited from the past. A digging stick I can make, but nobody but the sacred ancestors made the land and the waters. So therefore, only the group descended from those ancestors can own that property, must own it jointly, and must look after it and pass it on to the next generation. That's not how it works in modern land title systems of settler states, European states and so on. They're market societies where the individual right to own, buy and sell property is fundamental. Very big difference. What has happened is that as Aboriginal groups have been institutionalised and forced into settlements, whether they be government-administered settlements or missions, is that people have been living in houses. A house is not amenable, really, to the communal forms of ownership of Aboriginal tradition. And so increasingly Aboriginal people want the British-style title or the Australian modern title, the individual title, over their house blocks so that they can own their house and look after it. Because that's the way that people live in modern society. And public forms of housing in Aboriginal communities have been scant and poorly maintained by governments. And it's the housing deficit, and it's an extreme deficit that lies at the bottom of the health crisis in the Aboriginal world because of overcrowding and poor conditions. And so at the same time, people want to preserve their communal titles, and in the midst of their communal titles have areas where something like a freehold system operates so that people can live in houses and do the business of being a citizen in a modern nation, but also at the same time retain the characteristics of Aboriginal society. And fundamental to that is the communal ownership of land and water.
Marcia Langton has watched the evolution of Australia's mining industry closely across the decades. She straddles both sides of mining conflicts. She supports the rights of traditional owners, demands protection of sacred sites, and advocates for consultation and good practice. She also supports the right of Aboriginal communities to embrace mining, to seek royalties and well-paying jobs. Since we recorded this interview, Langton has sparked controversy in Australia because some of her research has been financially supported by mining companies. But during the mining boom in 2010, she seemed to think that things were moving in the right direction.
The history of Australian mining and the conflict with Aboriginal people that's involved mining companies trying to gain access to Aboriginal land by denying them their rights, by excluding them from having any say, and even excluding them from mining towns and mining areas altogether, demonstrates that it's a dysfunctional way to approach gaining access to land. I've explained already that Aboriginal people have no right of veto over mining or any other development on their land once it's gained state government or Commonwealth government approval. Some mining companies have taken the view that having the government approval entitles them to ride roughshod over Aboriginal people and over Aboriginal rights. A number of cases have shown us that this is a waste of the company's time and money because Aboriginal people will resist. And some companies have realised that it is better to negotiate than litigate. It's better to negotiate than to cause conflict, because projects usually only proceed well when local communities, be they Aboriginal or other local communities, collaborate with the project. So one of the problems that's become evident in the mining boom is that there's a local impact on communities that's much more extreme than any previous Australian mining boom, and that is local inflation leading to labour shortages and increasing anger amongst all the local communities. So now it's not just Aboriginal people who are angry about the way that mining companies behave with contempt towards local people. Now it's many more people who are angry about the impacts of mining. They're angry about the environmental impact. They're angry about the economic impact, such as inflation. So you have, for instance, a labour shortage. To buy in labour, companies pay exorbitant wages and salaries and contractors' fees, and thereby cause local inflation on local services, accommodation, food, so that locals can no longer afford to live in their own towns. And there is a growing disparity between the highly paid mining workforce and locals who do not work for the mining company. And given what's called in Australia the tyranny of distance, that is the city-bush divide, the city-country divide, it's no longer a feasible strategy for companies to exploit the people in the country, to exploit the remoteness of these places by simply using fly-in, fly-out labour, building temporary mining accommodation camps and riding roughshod over local people by not offering them employment. It's no longer a feasible strategy to destroy their environments and walk away and leave a mess. And it's not only because of the requirement that companies comply with environmental legislation, it's also the ability of the company to conduct its project with the agreement of the local community and also the reputational issues for the company. Well, it's increasingly the case that companies now require local labour rather than expensive fly-in, fly-out labour. And the permanent part of the population of most of remote Australia is the Aboriginal population. So some companies got smart and they're employing local Aboriginal people. And in one company, the proportion of Aboriginal people working for the company is 8%, whereas the Aboriginal population as a percentage of the total population of Australia is less than 3%. So in the remote mining areas, the Aboriginal population is usually much, much higher than 3%. The Aboriginal population might be 20% or even 40% of the local population, but they are the most disadvantaged part of the population. And mining companies do and will get the blame for the increasing disadvantage of locals as the mining towns become oases of wealth in these mining provinces. And these issues are increasingly being raised at annual general meetings, at shareholder meetings, in the media, and I don't think it's going to be possible for mining companies, including Chinese-owned companies, to ride roughshod over locals because governments will need to protect their local populations, and that means that there need to be good practice standards for the way that companies go about business, and that includes from the beginning of the proposal, that is gaining access to land, through to the closure of the mine. There need to be all sorts of forms of consent, consultation, informed consent from the local population, and the involvement of the local population in these projects. And it's not just the present population who are affected by these operations, but it's also the future generations who are affected by these operations. And I think even governments, as slow as they are to wake up to the downside of mining booms, are starting to realise that the Australian population itself depends on good policy and good practice in the way that the citizens of Australia are treated, and that includes the Aboriginal citizens.
We were specifically talking to Marcia Langton to understand the story we'd filmed about the Gidangji community's fight to stop the relocation of the MacArthur River to enable open-pit zinc mining in the riverbed at a sacred site inhabited by the rainbow serpent, the powerful ancestral being that created the land and enforces the law. Professor Langton had some advice for the MacArthur River Mining Company and the local government.
The risk that the company runs in going to the Northern Territory government, and it's a risk that the Northern Territory government itself bears as well, is that by overriding good practice, by changing the law so that Aboriginal people have no right to appeal in court, so that the Aboriginal landowners have no legal basis to protect themselves from the detrimental social and environmental impacts, is that when it comes to that company applying for a mining operation somewhere else, be it in Australia or elsewhere in the world, that case will show how poor their track record is in dealing with local people and local people's interests. It will show that the company has no regard for the local people and the damage that it causes to them. And it also shows people everywhere that the Northern Territory government similarly has no regard for its own citizens. Now, it's a large company, and it will have operations elsewhere in the world, and one would have thought that, like some other companies, it might give some thought to the long-term future of its operations and the reputational issues. Why would any local group cooperate with a mining company if its track record somewhere in the world is the destruction of the life of a local group, the destruction of the environment? Aboriginal people are no longer illiterate and cut off from the rest of the world. They have the web, they have telephones, and they have television. So all they have to do is put a company name into Google and they'll find the history of the company. And the same goes for anybody else in the world. We can find out, any of us, what the track record of a company is. And if they want to move into our part of the world, well, we can find out who they are and make up our minds about whether or not we want them around. And people now have access to all kinds of tools in running campaigns, and companies are up against more and more sophisticated community campaigning, should they wish to be disrespectful of community wishes. So it's not always going to be the case that the local community wins. Sadly, throughout the world, the reverse is mostly the case. But in countries like Australia, and here we are in another mining boom, it's simply not acceptable that a company behaves in this way. And there are other cases in Australia where a company has simply closed a mining operation because it would be better in the long run to only open the mine when the traditional owners agree. So even if there is no legal right of veto, good practice is to seek consent. And that's actually a human rights obligation that Australia's committed itself to by agreeing to the terms of the International Declaration on the Rights of Indigenous People.
We had also filmed in the remote bush of Arnhem Land in the Northern Territory, where a revered elder was reintroducing the old ways. Marcia Langton saw it as a hopeful story.
Gupawanamu is an example of traditional Aboriginal land management conducted in a collaborative way with scientists and others to show that traditional Aboriginal land management works, and it works particularly well as a new form of doing business in the green economy. So you have in Australia this annual round of wildfires. Now, in Arnhem Land, traditional people were enticed out of the escarpment areas from the 1950s onwards by ration depots and missionaries and government officials, and with none of the traditional owners living up there just for that short period, for 30-odd years, and therefore no Aboriginal land management, that is, the use of the cool fires, burning in a mosaic pattern annually or biannually, the wildfires got out of control and they burnt across the escarpment down into the Kakadu National Park. And, you will have seen the maps, the fire maps of the extent of the wildfires that occur without traditional Aboriginal fire management. When the old man from there sought to reinstitute the traditional way of life, the traditional fire management, he received support from people who realised the significance of what he was saying, and that with so much work done, identifying the vegetation communities, documenting the reduction in carbon emissions and so on, and modelling traditional Aboriginal land management as it occurs in the landscape, they were able then to offer the Gupawanamu project to ConocoPhillips as a carbon abatement project which the company could invest in to offset its environmental impact. So the result was a marvellous agreement involving the Northern Territory Government, ConocoPhillips, the Northern Land Council and the traditional owners of Western Arnhem Land. And so it's a beautiful case of the relevance of Aboriginal land management, which has been practiced for thousands of years, the stewardship of landscapes in the most difficult circumstances as a way of preserving biodiversity and reducing carbon emissions.
Professor Langton warned about the perils of not following Aboriginal land management practices.
The human species is in a very precarious position at this point in history. So much environmental damage has been caused by human societies, and there's climate change. There's the rapid growth of the human population, increasing urbanisation and increasing environmental destruction and destruction of our biodiversity and pollution of our air and water and rivers and soil. Is the world learning from its history? No, I don't think so. Because now we have the emerging economies. Are they showing any regard for the environment? Well, they're learning the hard way, that if you put poison into your air and water, then you will be poisoned. But it seems to be taking them a long time to figure it out. Perhaps not as long as it took the imperial powers to work it out, as they became the industrial powers in the first industrial revolution. But has anybody learned anything about the fragility of human society and the need to preserve human diversity, cultural diversity, linguistic diversity? I'm cynical about the purported commitment of the Australian government to the rights of Indigenous people, because it is so easy for people who believe in the supremacy of the modern European society to declare Aboriginal people the enemies of their way of life. And you have also the extraordinary irony of some environmental groups which regard Aboriginal people and their stewardship of the Australian landscapes and environments for thousands of years as the enemy of the environment. So I remain cynical. I think that we all must remain vigilant, and there are so many ways in which racism creeps into our lives. Racism evolves. Forms of racism emerge constantly. We now have cyber racism. We have environmental racism. And I'm afraid that with the emerging economies becoming the new powers in the global market, that even more Indigenous groups are in an extremely vulnerable position.
Marcia Langton has received criticism from mainstream environmental groups for trying to find a way for Aboriginal people and mining companies to benefit each other. I asked her to expand on her criticism of the environmental groups' approach.
There are many environmental groups, not science-based groups, but, local campaign environmental groups who regard the Aboriginal presence in the landscape as the problem. They don't understand that if you look objectively at Aboriginal history and a settler Australian history that actually the problem is the settler way of living on this continent is not compatible with the natural environment. But Aboriginal people made adjustments and adaptations over millennia, but the new kind of settler ideology is that Aboriginal people are the environmental vandals and the white people are here to save the planet. So I just find it extraordinary that environmental groups have taken steps in a number of jurisdictions to prevent Aboriginal people from having any say in their land. An example is the Wild Rivers legislation in Queensland, which excludes Aboriginal people from the economic use of, in Cape York alone, 13 river basins. And for some reason, the government believes the environmental lobby groups that settler control of rivers is a better thing for the environment, when it's very clear that the track record is actually the death of rivers, like the Murray-Darling River Basin, which is massive. It's the biggest river basin in southern Australia. It stretches across 3 states. It's a huge political problem, and the 3 states, New South Wales, Victoria and South Australia, are unable to agree on how to stop the death of that river. So the comparison of the Aboriginal deep history and the settler history, when you look at it objectively, shows that the continent was under the stewardship of Aboriginal people for 60,000 years, resulting in a paradise, which was then colonised by the British, and after which there were terrible environmental impacts, resulting in the destruction of the beautiful landscapes essentially shaped and stewarded by Aboriginal populations.
In 2008, Australian Prime Minister Kevin Rudd issued a historic, formal apology to Aboriginal Australians for the forced removal of children from their families, cultures, and communities. Thousands of children were sent to residential schools from the late 1800s into the 1970s. I wanted to understand how that apology came about.
In the 1990s, the Human Rights and Equal Opportunity Commission was asked by the Australian government to conduct an inquiry into the removal of Aboriginal children from their families. Now, across most Australian jurisdictions, there were departments of Native Affairs or the equivalent thereof, and the policy from 1938 onwards was to prevent the Aboriginal population from increasing and to force the Aboriginal population to assimilate. And so the way that they achieved this was by removing children from their families, forcibly removing part Aboriginal children or half-caste or quarter-caste children from their families and putting them into institutions where they were trained to be domestic labour or farm labour. So thousands of Aboriginal children were removed and placed into institutional care. Their lives were severely damaged. Many of my friends came from this background. And I know at first hand how emotionally damaging that the incarceration in institutions and often fostering into families where they were used as cheap labour was. For some people it was a happy experience, but for so many people it was far from the kind of childhood that, each child is entitled to. So gradually the evidence for this practice was built up by historians such as Peter Reid, Aboriginal groups which called themselves Link Up. The victims of these policies began looking for their Aboriginal families when they realised that they were Aboriginal. They were actually lied to about being Aboriginal in many cases. So it was such an extensive practice and it continued for so long. And it's clear that at least in Western Australia, if not elsewhere, according to the Human Rights and Equal Opportunity Commission inquiry report, constituted genocide in relation to Part E of the definition of genocide in the UN Genocide Convention. Where genocide has occurred, there must be repatriations. And a part of the repatriation process, according to international law, is an apology. And so many Australians denied this history and continued to deny this history. There's a man whose name is Keith Windshuttle. He continues to deny that any of this occurred. And there are others. Geoffrey Partington also continues to deny that this occurred, whereas, of course, the evidence is overwhelming. Many of the people who deny that this occurred, really putting the argument that, well, it was the best thing for Aborigines because their families are so backward, their way of life is so backward. They argue that Aboriginal children were being rescued from an Aboriginal way of life. And so it's basically a racial argument. It's a kind of fascism, that's being argued. It's a kind of ethnic cleansing argument. And they can't see that they themselves are participating in, the genocide. So I felt it was tremendously important to put the case clearly. Now, despite the best efforts of many people of the stolen generations, they were not by themselves able to convince Australians that an apology was necessary. I felt their campaign was brilliant. They asked Australians to sign what they called sorry books, and thousands of Australians signed books to say that they were sorry. And it was that campaign which was completely ignored by John Howard's federal government, and it was Kevin Rudd's party which didn't quite make the promise, hinted that the right thing to do would be to make an apology. And it was a populist move on the part of the Labor Party to lead people to believe that it would make an apology when it came to power. And I don't think they themselves suspected how strongly most Australians felt about this. But of course, political parties listened to the loudest. And the loudest voices were the denialists, and so I felt it was necessary to join in the debate on behalf of my friends. I think it's fair to say that there is no Aboriginal family that's not affected by the policies of removing children, whether in this generation or previous generations. And the pain that it causes in Aboriginal families is palpable. It is such a large-scale series of historical events that it resulted, when it became clear as to the extent of the policies and the impact of the policies, a stain on the nation's relationship with Aboriginal people.
As she had done in the struggles for land rights and protection of sacred sites, by adding her influential voice as a crucial advocate, demanding acknowledgement of past injustices, Marcia Langton once again played a key role, helping a national campaign succeed.
Because of the power of the campaigns run by the stolen generations, involving the sorry books and marches across bridges, it was impossible for Australians to claim a place amongst civilised nations in the world without addressing this historical problem. Essentially, the nation was built on the theft of Aboriginal land, the destruction of the Aboriginal population, which involved, at least in part, removing children from their families in an attempt at enforced assimilation. And most Australians did not want their children to inherit a nation based on a crime against humanity. And there's no question that this was the nature of the relationship. There was the Human Rights and Equal Opportunity Commission inquiry, and then, of course, after that, the stories of hundreds of people who had been removed from their families. There were the stories, too, of the people who had adopted Aboriginal children in good faith without understanding what they'd become involved in. And there were the stories of the brutal institutions where children were abused. And so the apology allowed the nation the honour that Australians wanted. And without an apology, the stain continued. And people were so relieved by the apology. There were thousands of people all over the country watching the apology on television screens, in workplaces, in public places, even in London, and wherever Australians are in the world, they watched the apology on television. And it made a difference. It made an enormous difference. And so many people said after the apology that it had made a difference to the way they felt about being Australian. And for many of us, it also meant that then we could move on from that problem, which had become the centre of the debate about Australia's Indigenous people, and we could move on to the pressing problems of the levels of disadvantage which Aboriginal and Torres Strait Islander people suffer in employment, education, health, and start addressing those problems. Without the apology, we would not be able to do that. And so it's no coincidence that the Closing the Gap policies announced by the present government were able to be implemented with the agreement of the Aboriginal population. So the apology was necessary both for the Australian people's pride and honour of the nation, and also so that we could get on with the business of solving the problems of Indigenous disadvantage, which result in extraordinary mortality rates and morbidity rates.
The trauma inflicted on the stolen generations was certainly something that it was important to apologize for. But Australia, and the United States for that matter, have yet to apologize for stolen land and desecrated sacred sites. There's always more to fight for. Visit sacredland.org to learn more about our films, resources, and suggested actions you can take to protect sacred places. Tune into the next episode of Sacred Land Speaks for a rebroadcast of Part 1 of my interview with the late Barry Lopez, the award-winning author who was one of the big thinkers in our Standing on Sacred Ground film series. If you like what you've heard, please rate and subscribe to Sacred Land Speaks on your favorite podcast app. This episode was produced and written by Toby McLeod and Callie Shanafelt Wong. Our interview and video footage with Marcia Langton was recorded by Andy Black and Dave Wendlinger. Our theme music was composed and performed by Stefan Smith and Charles Johnson. Sacred Land Speaks is brought to you by the Sacred Land Film Project of Earth Island Institute, based in the Lisjan Ohlone territory of Huchiun, otherwise known as Berkeley, California. Thanks for joining us.